Hello, I'm State Representative Kimberly Mosier, representing the 64th District of Kentucky. I am also the chair for the Health Services Committee and a member of the Kentucky Judicial Commission on Mental Health. House Bill 385, or Seth's Law, is legislation that came from the collaborative work of the Kentucky Judicial Commission on Mental Health, a high-level stakeholder commission established by the Kentucky Supreme Court to implement transformational changes to individuals experiencing mental illness, substance use disorder, or an intellectual or developmental disability. Seth's Law was the product of collaboration as multiple work groups came together to create one legislative package impacting two priorities for the Commission, including guardianship and competency. The first part of House Bill 385 allows individuals with little or no family to have a trusted friend make medical decisions on his or her behalf. This will reduce the number of cases handled by state guardianship, as a significant other, neighbor, or a friend can step up to help in the time of a medical crisis and will alleviate the burden on state resources, including the court system. Under current state law, a state-appointed guardian or someone unfamiliar with the individual makes decisions on behalf of the individual in such circumstances. This bill allows medical decisions to be made by someone familiar with the individual who is knowledgeable of the person's religious or personal preferences. The addition of friend is modeled after similar legislation enacted in 2021 in Indiana. The second part of House Bill 385 allows a defendant where competency to stand trial is an issue to be evaluated on an outpatient basis by either a psychologist or a psychiatrist, and if further evaluation is needed, a defendant is then referred to an inpatient facility. Outpatient evaluations may be rendered at the jail, community, or any other setting outside of the Kentucky Correctional Psychiatric Center, or KCPC. This is for felony offenses or the designated state hospital for misdemeanor offenses. As a result, it is anticipated that defendants eligible for an outpatient competency evaluation will be evaluated within 3 to 5 weeks, which will expedite the court process, providing quicker justice to victims while reducing the wait list for those in need of inpatient services. Lastly, House Bill 385 was named in honor of Seth Stevens, who previously served as an attorney for the Kentucky Judicial Commission on Mental Health. Seth was a champion for mental health reform, passionate about both competency and guardianship reform, who tragically died by suicide in 2023. Seth's Law is a product of true collaboration, and this video will provide an overview of the bill and its impacts on Kentucky practices.
Hello, my name is Wesley Duke and I serve as General Counsel for the Cabinet for Health and Family Services, known as CHFS. CHFS oversees the Department of Aging and Independent Living and the Division of Guardianship, which are positively affected by Seth's Law. The changes allow for trusted friends to help with medical decisions for individuals who otherwise would have been appointed a state guardian because they are deemed to lack decisional capacity or have not executed an advance directive. The Cabinet also has purview over the state psychiatric hospitals through the Department for Behavioral Health, Developmental and Intellectual Disabilities, known as DBH-DID, which is designated as the state's mental health authority. This work includes the handling of competency and criminal responsibility evaluations for felony and misdemeanor charges throughout the state. The mission of the Department for Behavioral Health is to promote health, well-being, and resilience for all, facilitate recovery for people affected by mental illness and substance abuse, and support people with intellectual and other developmental disabilities. Our vision is that all Kentuckians have access to quality services and supports to live full and healthy lives with values that include choice, respect, equity, excellence, and advocacy through trauma-informed and resilience-oriented approaches. Seth's Law fosters improved access to healthcare services based on these values. I will now turn it over to Judge Mayer to discuss the statutory changes of Seth's Law.
Hi, I'm Cole Adams Mayer, a circuit judge in the 25th Judicial Circuit, Clark and Madison counties. I'm also a member of the Kentucky Judicial Mental Health Commission and serve as the chair of the Commission's Criminal Justice Committee. House Bill 385, which is commonly referred to as Seth's Law, may alter the way you are currently conducting business in courtrooms across the Commonwealth. I'm going to take a few moments to summarize the statutory changes that impact proceedings under KRS Chapter 504. This legislation defines a treatment facility to mean an institution or part thereof approved by the Cabinet for Health and Family Services, which provides evaluation, care, and/or treatment for insane or mentally ill persons or individuals with an intellectual disability on an inpatient or outpatient basis. That definition is substantially similar to the existing definition provided in KRS 504.060. Right now, this impacts the Kentucky Correctional Psychiatric Center, commonly referred to as KCPC, and our state psychiatric hospitals. The court may order a defendant to be examined on an outpatient basis when the defendant is believed to be incompetent to stand trial, intends to assert a defense of insanity at the time of the commission of the offense, or intends to introduce evidence of mental illness or intellectual disability bearing on the issues of guilt, punishment, or both. Consistent with the Kentucky Rules of Criminal Procedure, an insanity defense or the intention to introduce expert evidence relating to mental disease or defect or any other mental condition of the defendant bearing on guilt and/or punishment must be raised 90 days before the commencement of a trial. The existing version of KRS 504.070 states that written intention to introduce evidence of mental illness or insanity must be filed 20 days before the start of the trial. But Seth's Law amends the statute for consistency with our criminal rules. On the effective date, KRS 504.070 and Criminal Rule 807 will both require 90-day notice. House Bill 385 makes Chapter 504 language more consistent with our criminal rules by using the language bearing on the issue of guilt, punishment, or both. This acknowledges that in addition to competency or criminal responsibility evaluations, KCPC receives examination orders that address extreme emotional disturbance and evaluations for individuals with intellectual disabilities or mental illness as part of an Atkins evaluation to help the court determine whether the death penalty can be excluded as a sentencing option. As amended KRS 504.080, the court may order an examination on an outpatient basis. That initial examination should occur roughly 4 weeks from the receipt of the order for examination. If the examiner concludes that an inpatient examination is needed, the court may order the defendant be committed to a forensic psychiatric facility, KCPC, or its designee for no more than 30 days and treated for his or her mental condition, subject to the availability of the facility if necessary. As amended, KRS 504.080 states that the examiner must issue and deliver a report consistent with the court's order no later than 10 days after the examination. After the report is filed, the court shall order the report to be filed under seal, provide notice of filing to all parties, and shall schedule the case for a status conference or hearing no more than 30 days after the filing of the report. If a defendant is found to be incompetent but likely to regain competency in the foreseeable future, the court shall commit the defendant to a treatment facility or a forensic psychiatric facility and order the defendant to submit to treatment for 60 days, except that if the defendant is charged with a felony, he or she shall be committed to a forensic psychiatric facility unless the Secretary of the Cabinet for Health and Family Services or the Secretary's designee determines that the defendant shall be treated in another Cabinet for Health and Family Services facility. It is important to understand that Seth's Law represents a shift in how competency evaluations are integrated into our judicial processes. These statutory changes aim to improve consistency and efficiency, ensuring that defendants receive the appropriate care and evaluations necessary for their cases. As we prepare for the implementation of Seth's Law on July 15, 2024, it is crucial for all parties involved to familiarize themselves with these changes. This includes understanding the new timelines, the revised criteria for outpatient and inpatient evaluations, and the updated procedures for handling competency defenses. The continuing goal is to uphold justice while providing the necessary support and resources for defendants with mental health issues. By adhering to the new procedures outlined in Seth's Law, we can better serve our community, ensuring that our legal and behavioral health systems work in tandem to address these complex cases effectively.
Hello, my name is Colleen Slusher, and I serve as the director of the Kentucky Correctional Psychiatric Center, known as KCPC, which is designated as the sole forensic psychiatric hospital for the state of Kentucky. KCPC serves the evaluation and treatment needs for felony-level cases for all of the state's 120 counties, as well as individuals who are adjudicated incompetent to stand trial with qualifying offenses who require civil commitment under KRS 202C. Seth's law formally implements statewide system change beginning on July 15th of 2024 by ordering outpatient evaluations as the starting point for competency to stand trial and criminal responsibility evaluations. The defendant will be evaluated as an outpatient, which is defined as any modality outside of an inpatient at KCPC or any state psychiatric hospital, and the defendant will be only referred for inpatient evaluation or treatment by an evaluator. This applies to all charges and cases across all state hospital facilities, both felony and misdemeanor. The Kentucky Correctional Psychiatric Center, KCPC, began the initial pilot process for outpatient evaluations in May of 2022 to modernize the forensic system and align with national practices on forensic health care. Since its inception, KCPC has built partnerships with 122 correctional facilities throughout the state to facilitate evaluations. The state psychiatric hospital process will mirror the same process as KCPC for all misdemeanor cases. This means that if an evaluation needs to occur in a county jail on a misdemeanor case, then the state hospital and jail will follow the same process that the jail currently follows with KCPC to facilitate the outpatient evaluation. This is true whether the evaluation occurs through a video conference or in person at the jail. To reiterate, outpatient evaluations are any evaluation that occurs outside of a state hospital. These occur through video conference, in person in jails, or other community facility or office. The identified changes in Seth's law follow Tennessee's model, which has successfully been completing outpatient evaluations since February of 1974. This video is intended to formalize communication with all stakeholders so that everyone has the necessary information. Model legal forms will be developed by the Administrative Office of the Courts. Currently, there are sample forms available through KCPC. Please contact KCPC's Admissions Department to request these forms at kcpcadmissions@ky.gov. The release of a one-page summary of what has been discussed in the video today will be shared widely with stakeholders. Thank you for taking the time to learn about Seth's law. We hope to honor his memory with the work moving forward. Please do not hesitate to contact us with any questions.